You sued your doctor for medical malpractice and the defense refuses to negotiate, claiming they did nothing wrong. But now, 2 years during the course of litigation, now your case is approaching trial, and guess what? Now all of a sudden the defense wants to try and negotiate. But they want to try and do it privately, through a private judge known as a mediator. Through the process of mediation, can your attorney go to a mediation and then walk out and not settle your case? You want to know the answer? Come join me for a minute as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, he can. The mere fact that the defense now, after 2 years of hard-fought litigation, wants to try and negotiate, and now they want to negotiate not by attorney to attorney, but rather they want a judge, an impartial judge, to try and help them negotiate this case, known as a mediation. That's a private negotiation process that occurs outside of the courtroom. So each side goes ahead and agrees on an impartial judge, which we call a mediator, and now all the parties get together and they meet in the judge's conference room. So who's there? I am there as your attorney. You will be there. The defense attorney will be there. Sometimes the doctor will be there. And the impartial judge will be there. Now, this judge knows nothing about the case, but the mediation is an opportunity to do a number of things. It's an opportunity to go ahead and test out some of our trial theories. It's an opportunity to put our best foot forward to show to the judge and our opponent, hey, we've got the goods, we've got the evidence, we've got the testimony. Here's what we're going to show in just a few weeks when the case gets to trial. And now, after we put on our brief presentation, the defense will have an opportunity to do the same exact thing, to show the judge why they believe that we don't have a valid case, why they believe that there's no liability, and that the doctor did not violate the standard of care, and that even if he did, whatever he did didn't cause or contribute to your injuries. Now, here's a question that some people have. The mere fact that the defense has now engaged us and called us up and said, hey, Mr. Oginski, we'd like to try and begin negotiations. Are you open to the possibility of trying to negotiate through an impartial judge known as a mediator? And the answer typically is yes, we're open to that possibility. And now an injured patient gets so excited thinking, okay, for 2 years the defense has refused to negotiate. For 2 years the defense has refused to acknowledge that they did anything wrong, or that at least there was the possibility they did something wrong. And now, here they are coming to us, they want to negotiate? Wow, that must mean that they want to settle this case. The mere fact that they want to engage in settlement discussions, you should understand, does not mean that you're going to settle this case. And you might be saying, why? Why not? How could they not want to settle this case? Now, I didn't say they don't want to settle the case at this point. Now, they may have evaluated their risk. Now they may have studied the risk compared to what a jury might do at verdict. And now, weighing those risks, they may turn around and say, you know what? It might be better if we try and negotiate this case, if we can settle this case out of court for a low amount of money, which will eliminate the risk of having a jury come back with a very significant verdict and then having to take an appeal. That's a possibility. But the mere fact that the defense has now wanted to engage us in trying to negotiate this case does not by any stretch of the imagination mean that you're going to negotiate and settle your case. In that instance, where the defense doesn't come up to a number, settlement number, which we believe is reasonable and appropriate for your particular case, then you know what we do? We pack up, we tell the judge thank you so much, let the defense know thank you, but no thank you. We are leaving. And we get up and we walk out the door. And there are some instances where the defense turns around, chases us down the hall, and says, wait, Mr. Oginski, come back in, please. And other instances, they say, fine, we'll see you at trial. Which one will happen in your particular case? The reality is, nobody knows until it happens. And then you'll have to make an on-the-spot decision about what you want to do. Are you willing to try and negotiate further? Do you want to have further conversations? Or are we done talking? And that's it. We'll see you at trial. So why do I share this great information with you? I share it with you while the dog is barking in the background. He's probably hungry, he wants to go for a walk. But I share it with you just to give you an insight into what really goes on in these medical malpractice cases, in these accident cases, and even in these wrongful death cases here in New York. You know, I understand you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, and you still have questions about your matter, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.